I call Dennis O'Rourke.
Mr Speaker, New Zealand First would have wished to support this bill as a whole because New Zealand First is strong on law and order and wishes to see, as I'm sure everyone in this House does, effective enforcement of law and order in this country. But that doesn't mean that anything goes. New Zealand First says that the most serious problem with this bill and the fundamental reason why it cannot be supported by New Zealand First is the loss of the right to silence in some circumstances. And of course I refer to the examination orders sections 31 and 32, police powers in a business context where the offences may be punishable by 5 years or more, but more particularly the examination orders sections 33 and 34 relating to a business context and offences punishable by 7 years or more. The questions which New Zealand First and which I ask, Mr Speaker, are these. First of all, is the loss of the right to silence, even in these limited ways, justified by the gains for law enforcement expected? And secondly, are we, as law-abiding citizens, willing to lose these rights in this incremental kind of way as the price for a dubious improvement in the collection of evidence for crimes of serious fraud? And the answer to that has to be, especially in relation to the second question, no. And unlike ACT, for example, New Zealand First does want effective law enforcement without unnecessarily wide losses of such rights. New Zealand First has special concern over sections 33 and 34 relating to the non-business context. And of course, non-business context as defined in the Act means in relation to the acquisition of any information by any person in the person's capacity as a provider of professional services or professional advice in relation to a person who is being investigated, or be a director, manager, officer, trustee or employee of an entity that is being investigated. So when it comes to the non-business context, anyone not in those categories I've just read out, the net is very, very wide indeed. And I suggest, Mr Speaker, far, far too wide. The loss of the right to silence for people who are not professionals in that way or not officers or employees of the organisation being investigated is completely unacceptable and a very, very serious reduction in our hard-won right to silence in this country. And the seriousness of removing that right should not be underestimated. It is an important part of due process. And as we know, that started way back in 1352 under Edward III, where due process was first regarded as an important part of the legal system. And then came the Star Chamber and its abuses in the 16th century, after which the right to silence was developed and has become a very important part of our legal system. And that was culminated by Miranda in 1966, in which people had to be told that they had the right to silence. And now we're looking at reducing it again. We should not abrogate such important rights unless we exercise great caution in doing so. And not enough has been shown in this bill, especially in respect of those sections to which I have referred. And in practical ways, remember that it is not necessarily the person who is being accused, something which Mr Banks didn't seem to appreciate, not necessarily the person who is being accused who will be required to speak under this legislation. So we are not just targeting here criminals, we're targeting people who are regarded as being able to assist the police. And they will have a trilemma. They will either have to speak and perhaps risk perjuring themselves and be punished for that, or they can refuse to speak and be punished for that, or they can speak and potentially incriminate themselves. And I don't accept, for example, that the simple statement in section 132 of the bill is sufficient to protect those people from self-incrimination. A simple statement doesn't do it in practice. So what is the real value of the evidence sought in this way? It's not very great indeed. So we lose some important rights and get very little back for it, and that's the point. This is especially so in relation to the non-business context. I would also say this: why do the police have similar powers to the SFO, but the SFO is not covered in the bill? Now, I have been persuaded by the arguments from the Labour Party in that respect. I think they're quite correct. It is simply illogical that the SFO is not included with the safeguards that are provided in this bill. And we should also, in fact, go a little bit further and require the police, in conjunction with the SFO, to pursue the objectives of law and order in these ways. But I also think that sections 33 and 34 may go too far in respect of who will ultimately get those powers, and that's been referred to by my friend in the Green Party. How many people will ultimately get these powers? Where will it all end up? Are we, step by step, moving towards a police state? I think maybe we are, but especially sections 33 and 34 do enable abrogation of the right to silence. In too many cases, the power to do that is far too wide and shouldn't go that far. Now, in going too far, Mr. Speaker, perhaps those promoting this bill are unwittingly building a police state, step by step. I say unwittingly to be charitable, because I do think that they do know what they are doing here and are simply not willing to accept the fact that they are going too far. Now, Mr. Speaker, the government, and I would say especially the ACT Party, are generally opposed to excessive government, legislation and excessive regulation. But here we see them doing a lot more than that, willingly moving towards the loss of important rights in the way I've described. Those rights, as Mr. Banks correctly said, are hard fought for and are now reduced for very little gain. These provisions are not required for good law and order and are of dubious value, especially in the non-business context. New Zealand First has a strong policy on effective law and order. However, we think that is completely compatible, unlike the Minister listening to some of her speeches, with the requirement for the protection of basic democratic rights in this country. Now, I understand that effective law and order is necessary and we need to use effective modern methods to achieve it. And the balance is very important. But balance is one thing, the abrogation of important rights is another, and that's what's not been addressed properly here. The right to silence is one of those rights, and as I repeat again, the problem is not that it is lost in cases where it's justified, perhaps where professionals are giving advice and need to answer questions, perhaps where officers of a company can give information and should do so, but beyond that, it is going too far. And that is the problem that New Zealand First fundamentally sees with this legislation, in addition to the other reservations which I have expressed. The price asked, therefore, for a dubious improvement in effectiveness of law enforcement is far too high. The value of the right to silence should be given much more attention than the government is willing to do. And for those reasons, Mr. Speaker, New Zealand First has no option but to oppose this bill.
I call Simon Bridges.
Mr. Speaker, I'm